I gave her the memo and I resigned. And I said, I don't know fully what's going on here, but I am not going to be a part of this.
And he raised over $1 million that went to schools and medical supplies in Iraq.
Hello, my name is Stanley Heller. Welcome to The Struggle. The Struggle is shown on 22 cable stations from Vermont to New York City, on the internet at thestruggle.org, our YouTube channel, Struggle Video Media. We begin with a lawyer for a man on the run. Jesselyn Radack is counsel for Edward Snowden, who leaked government documents about the massive spying campaign the U.S. does on world leaders and on American citizens. The reports made by the British Guardian and the Washington Post using Snowden's material got them the Pulitzer Prize. Yet Snowden is in hiding in Russia. Then Lynne Jackson of Project Salam. She talks about the case of Rafil Dhafir, who's being jailed for decades because he defied the sanctions on Iraq that had killed so many hundreds of thousands of children. We begin with Jesselyn Radack, who spoke at a meeting on government mistreatment of whistleblowers at Yale Law School. She's introduced by the eminent Ralph Nader.
Jesselyn Radack is director of a wonderful group, which I had a hand in inspiring, but it's gone way, way beyond my anticipation. It's called the Government Accountability Project. It's the nation's leading whistleblower organization.
But my story, how did I get this job? After graduating from Yale Law School here, I went to the Department of Justice through the Attorney General's Honor Program right after law school. I practiced constitutional tort litigation for 4 years, and then I became the ethics advisor. By then I had a couple of children and couldn't deal with the travel and deadlines of litigation. I needed a little stay-at-home time, so I did ethics policy. And I myself became a whistleblower because I was attorney consulted right after 9/11 when America captured its first detainee in the Afghanistan war, John Walker Lindh. You may have heard of him referred to as the American Taliban. I was asked about the ethical propriety of interrogating him, and I was told matter-of-factly that he had counsel and he's an American. Your constitutional rights follow you outside of the country, and so I advised, as I did in pretty much every similar kind of case, that if someone is represented by counsel in the matter, you cannot interrogate them without their attorney. That was on a Friday. On Monday, the criminal division called back, saying that the FBI had ignored our advice, and what do we do now? Again, I said not to worry. FBI could be cowboys sometimes, and there were ways to deal with this by sealing off the interview and using it for national security or intelligence purposes, but not for criminal prosecution, which is exactly what the Justice Department proceeded to do. There was an atmosphere of hysteria after 9/11 that pervaded everything and everyone in this country. And that's not strange following a national security crisis. Our pendulum swings in a very nationalistic direction, and usually eventually swings back, but instead has swung even further. When the Justice Department continued this criminal prosecution, I inadvertently learned that there was a federal discovery order for all internal justice correspondence related to Lynn's interrogation. And the prosecutor wanted to know if he had everything. And he told me, I have 2 of your emails. Well, 1, no one told me about that discovery order. And 2, I had written way more than 2 emails. But being a naive 29-year-old, like my client Edward Snowden, I went and checked the hard copy file because that's how we kept things back then. When I went and checked the file, there were 2 pieces of paper in what had been an inch-thick stack. And my heart just fell to my stomach, and I was still in disbelief, so I consulted a very senior colleague of mine. I said, "What's going on here?" And he looked at the file and said very matter-of-factly, "This file has been purged," which was inconceivable to me because the department was simultaneously prosecuting Enron and Arthur Anderson for destruction of evidence and obstruction of justice. So I called technical support. We had just gotten the internet about a year before. And I managed to resurrect more than a dozen emails, including the one documenting the FBI's ethical misconduct in its interrogation of John Walker Lynn. It went beyond ethical misconduct into torture. If you remember the trophy photo going around the world of him blindfolded, gagged, bound to a board with duct tape, with horrible words written all over him. It foreshadowed what we later saw at Abu Ghraib, but right after 9/11, nobody flinched. I wrote a memo to my boss, and I attached the emails. I made a copy for myself in case they disappeared again, and I gave her the memo, and I resigned. And I said, I don't know fully what's going on here, but I am not going to be a part of this because thank you. Because the entire criminal case, it wasn't about John Walker Lynn or sympathy for him in particular. It was about following the rule of law. The entire criminal case against John Walker Lynn hinged on the validity of the confession that he gave during the interrogation that I had advised against, in which he was denied a lawyer, and during which he was also subjected to enhanced interrogation techniques called torture that I am under a gag order and can't talk to you about. So I left the department, started doing something completely unrelated in the law, and the department continued to say, we never thought he was entitled to a lawyer. And I didn't believe the Department of Justice would have the temerity to keep saying that if my emails had in fact been turned over to the court. I tried to go to the judge, Judge Lynn. I didn't have standing. I was told I didn't have standing and could not be heard. At that point, I went to the media because I could not live with the idea that someone else could be put to death because my email had not been turned over to the court. And the media, Newsweek in particular, wrote an article. The Lynn case ended in a surprise settlement. A couple of weeks later, he pled guilty to 2 minor administrative infractions for which he's serving 20 years. And I thought that was the end of this ordeal for me. But I didn't realize that by blowing the whistle, I had unleashed the full force of the entire executive branch. What did that mean for me? For me, it meant being under one of the first federal criminal leak prosecutions, investigations, and prosecutions, potential prosecutions. By the way, leaking is not a crime in this country. You have a First Amendment right to go to the press. And what I gave the press was completely unclassified. So I was put under a criminal investigation. The Justice Department referred me to the state bars in which I was licensed as an attorney. And for good measure, I was put on the no-fly list. Because surely, as a 7 months pregnant mom of 2 little ones, I pose a huge threat to aviation security. I was in the wilderness for a number of years, during which Bruce Fine defended me pro bono. I paid other attorneys upwards of $100,000 in attorney's fees, got a second mortgage on the house, was not bringing in a stream of income in a co-equal breadwinner house. So it was very difficult at those years. But it made me decide that I was going to dedicate the rest of my life to representing whistleblowers. So I went to work for the Government Accountability Project, GAP, where I represented whistleblowers who blew the whistle and did the right thing and faced retaliation like having their security clearance pulled, being demoted, being transferred to some meaningless position, stacking paper cups for $200,000 a year. At worst, getting fired. So in 2010, when I read that an NSA employee named Thomas Drake had been indicted, and had been indicted for espionage, which is one of the most serious charges you can level against an American. And from everything I could read, it sounded like classic whistleblower activity. I knew we had crossed a Rubicon. Tom was the first person against whom the Espionage Act had been used. It had been used first against Daniel Ellsberg 40 years earlier, the Pentagon Papers whistleblower. There were some 2 or 3 odd cases after that where it was used against people alleged to have mishandled classified information, and Tom Drake entered the history books as the 4th person. Since then, President Obama, for whom I campaigned, contributed to, and voted for, has brought 8 such Espionage Act charges, investigations, and prosecutions against people who were engaged in whistleblower activity. Tom Drake's case ended up crumbling beneath the weight of the truth because everything that the government alleged was classified turned out to be completely unclassified. In fact, it wasn't stamped classified until after it was seized from his house. A reason we have something in that piece of paper called the Constitution against ex post facto laws. But I guess we're not using that piece of paper that much anymore these days. But this unrelenting witch hunt against whistleblowers, I've always said this is really a backdoor war on journalists. And we didn't start seeing that until the subpoena of the AP, all the AP reporters, 23 different reporters' records, and a search warrant on Fox reporter Jim Risen's account. And he was called a co-conspirator for writing a story. Meanwhile, Jim Risen had been out here in the ether for a while under 2 subpoenas by Bush, and now a number of subpoenas by Obama to try to make him testify against a source. And ultimately, I view this as part of a wider war on information going on in our country against whistleblowers and journalists and hacktivists and people who dissent from the government party line. And it is a fast track to having an Official Secrets Act, which we have lived without for more than 200 years in this country. I know you think I'm maybe exaggerating, but what does it say that the 2 biggest scandals of the Bush administration, torture and secret surveillance, the 2 people who blew the whistle on that, 2 of my clients, Thomas Drake and John Kiriakou, the 2 people who spoke up about that have been the only people prosecuted in connection with those scandals. The people who tried to stop it or condemned it. That's appalling. In the case of secret surveillance, we enacted what I call Enabling Act legislation afterwards in the FISA Amendments Act to provide retroactive immunity to the telecoms that had violated a law, every violation of which is a felony. Then Obama gave blanket jurisdiction to CIA torturers by looking forward, not backwards. So if my client, John Kiriakou, had actually tortured someone, he wouldn't be in jail today. Meanwhile, if you read the Washington Post today, you read about a new form of torture, one we haven't heard about because it's in a 6,000-page report by the Senate that the CIA is trying to bury. Because it turns out, even though everyone who did it has immunity, the people who authorized it, ordered it, wrote the covering memos, including my classmate, John Yoo from Yale Law School. See, different people can come out of this place and do very different things. All of those people have immunity. Despite that, The CIA doesn't want that report to come out because we learned today, for example, not only were they waterboarding people, they tried to drown a detainee in a bath of ice water drowning of a human being. And why do we know about that? We know about that because of what are called authorized leaks, which is sort of an oxymoron if you ask me. But it's because US officials, who can only speak on the condition of anonymity because of the classified nature of this program, revealed that we did this. So they're trying to give you a little taste of what's in this report so it doesn't shock you too much. I think part of the war on terror and its aftermath has been inuring all of us, normalizing all of the bad behavior that we're engaged in. Yesterday, NSA, Chris Inglis, after the government begged the Washington Post not to name the country on which we were actually collecting every piece of content of telephone metadata, one of the NSA employees went ahead and told us it's Iraq. And Chris Inglis is not going to be prosecuted for espionage, nor is Leon Panetta, who did the same crime or committed the same crime that my client John Kiriakou did. John Kiriakou confirmed the identity of a supposedly undercover agent who had engaged in torture, rendition, interrogation. Getting thrown out by that. Leon Panetta revealed the identity of undercover intelligence agents to make a movie called Zero Dark 30. So while people who engaged in torture, like Jose Rodriguez, are enjoying their book tours, people like John Kiriakou, who is one of the most patriotic people I've met, and who has served his country his whole life, is in jail. And then, now we have Edward Snowden. It says a lot about a democracy that a whistleblower now has to leave the country. That is the safest way to make a disclosure without getting caught up in the legal system, is to leave the country to do so. What does that say about us? And, you know, for me, there are two attorneys in this country, me and Ben Weiser of the ACLU, who are publicly representing Snowden against a government that has the biggest microphone, biggest megaphone in the world. And all they can do is complain about maybe possible future potential harm with no evidence given. There's a reason that future harm is not actionable. I mean, you've probably studied that in torts, I hope. It's because it's very speculative and difficult to prove. And in fact, they've conceded the point that no harm has yet occurred by saying, well, there might be some kind of future harm. Just like they said, because of Tom Drake, NSA will go dark and the blood of soldiers will be on his hands. And as I said of Chelsea Manning, all this damage has damaged US for years to come. I went to that court-martial, which no one in the mainstream media did on a regular basis. The New York Times appeared twice for part of it, for a day. And the US produced not a single damage assessment. I would submit that the United States don't protest too much, but they don't stop. I mean, this is completely out of control. And right now, I am confident that Clapper and Alexander and Chris Inglis's and the Brennans and of the world, people aren't going to remember who they are. But Edward Snowden will go down favorably in the history books and will be remembered favorably. And you have to decide whether or not you want to be on the right side of history or the wrong.
May 12th is a day unique in American history. On that day, a top American official admitted that the U.S. was taking part in the mass murder of children. On that date in 1996, Madeleine Albright, who was then our U.S. ambassador to the United Nations, spoke on 60 Minutes, and she admitted that our sanctions on Iraq had killed over 500,000 children. The sanctions forbid Iraq from freely selling its oil. As a result, the government didn't have the money to import enough food and medicine, and the results were ghastly. The sanctions didn't end for another 7 years until the U.S. invaded and overthrew Saddam Hussein. We've campaigned for May 12th to be remembered as Iraq Genocide Memorial Day. We have a special section on our website all about it. One person did go to jail because of the murderous sanctions. Alas, not for enforcing them, but for breaking them. His name is Dr. Rafil Dhafir. At the One Nation Under Surveillance conference, I asked activist Lynne Jackson about him.
Dr. Rafil Dhafir was a very well-respected oncologist in Syracuse, New York. He is a naturalized U.S. citizen. He came here from Iraq. During the sanctions, before the Iraq War, the 10 years of sanctions, Dr. Dhafir was quite concerned about the state of people in his country, the country he came from, and he raised a great deal of money. I believe the charity was called Help the Needy, and he raised over $1 million that went to schools and medical supplies in Iraq. So what happened is the FBI raided his house one day. He was arrested while he was driving to work. His wife was kept in their house for many, many hours, not not allowed to get dressed or anything. She's wearing a nightgown. And he has never been free since.
What year was that?
I can't remember. I'm sorry. I'd have to look it up. I can't off the top of my head remember the year that he was arrested. So what happened is he went to trial. The trial lasted a very long time. And what was the trial about? It was about Medicare fraud. Now, usual cases of Medicare fraud involve, fake patients and fake billing, and that people make money off of pretending that someone was, being treated. But in Dr. Dhafir's case, that was not the case. In his case, he was an oncologist, and he really cared deeply for his patients. And the issue was this really minor Medicare provision as to whether he was available at the office when they received their treatment. So, for example, someone would get a chemotherapy treatment, and if Dr. Dhafir was available, then the charge would be $200 more than if he wasn't available. And the issue was, his argument was that he was available because he was available by phone at all times while people were being treated in his office. But the Medicare, they argued that he wasn't. This happened maybe, half a dozen times over the course of, a period of time. So it became a felony because it was, $1,200 or something. So whatever the multiplier is there. Now, if he'd been anybody else, what would have happened? Well, you would have adjusted the books. The Medicare would say, well, you owe us X amount of money. He would have paid the money, or they would have adjusted whatever. In his case, he was sentenced to 22 years in prison. 22 years in prison for something that, if he wasn't Muslim and from Iraq, not only would there have been no trial, there would have been no time, there would have been nothing.
But when he was arrested, wasn't there a lot of talk about terrorism?
Well, yes, but so this whole idea was that he was a terrorist, and the other issues that he had was how he raised the money, because there were no terrorist organizations in Iraq at the time that he raised money for charity. And so, but the government, so that's why the government went after Medicare, the quote Medicare fraud. But his charity was investigated, and my understanding is the night of the day he was arrested, the FBI also raided something like 150 Muslim homes of people who had donated money to his charity. Say it's quite appalling.
They convicted him on some charges of giving money that violated the sanctions on sending anything to Iraq under Saddam Hussein.
Yes, he was convicted, I believe, on some of those charges. But it was basically Medicare. But then they turned all this. He is on the Department of Justice list of terrorism cases, and he is considered a terrorist. Both he and his wife are on that list. But
they weren't convicted, or he wasn't convicted of anything giving money to any organization?
No money ever went to any kind of violence. All the money that he raised went to education, medical supplies, those kinds of things that were just not, because of the sanctions, Iraqi people couldn't get. And all the money went to that. And there was never, as far as I know, any accusations that any of the money went to any kind of violence or anything. But this is a typical case of preemptive prosecution where the government, they want to go after Dr. Dhafir because he raised money for Iraq during the sanctions. But they had to have some kind of handle, and that's why they combed through all of his bookkeeping to find these which typically pretty minor errors. And there was no fraud involved. I mean, the one thing about Dr. Dhafir is that he cared deeply about his patients, and if his patients could not afford the expensive chemotherapy, he would pay for it out of his own pocket. He did a lot in terms of charity. So he was given 22 years in prison for this. He was sent to the Communications Management Unit in Terre Haute, Indiana. He was one of the first people to go there, and he has suffered in that. He was in that prison for quite some time. I believe now he has been released to a medical institution, but he hasn't been out. So basically the FBI came, they arrested him, they took him away. He was held pre-trial in prison and jail pre-trial. So it makes it very hard to prepare your defense when they wouldn't let him out on bail. The trial went on for, it was quite a lengthy trial. I can't remember exactly how long, but it was a lengthy trial. And so the government basically, took over his medical practice, and he's never been out since.
We record this a month after the killing of Yusuf Shawamra. You recall, he was a 14-year-old boy trying to go to land of his family through a gap in Israel's apartheid separation fence, and then was shot without warning. Haaretz, their editorial board, called the act a war crime. Yet after a month, the Israeli government hasn't even uttered a word of criticism of the murder. More about this on our website. That's our program for today. See you next week at this time. I'm Stanley Heller, and this is The Struggle.